Question number 501. Two persons A and B fight with each other. A was having a blade with which A inflicts injury on the face of B, leaving permanent scar on the face of B. A is guilty of the offense of causing. Options are grievous hurt by sharp cutting object, grievous hurt by rash or negligent act, simple hurt by sharp cutting object, simple hurt by rash or negligent act. Here the correct answer is grievous hurt by sharp cutting object. Question number 502. A was beaten by A. In this act, A's shoulder was dislocated, not fractured. B is liable for, here B will be liable for the grievous hurt. Question number 503. Which kind of hurt is not grievous? Options are any hurt which endangers life, any hurt which causes the sufferer to be during the space of 15 days in severe bodily pain, permanent privation of the sight of either eye, privation of any member or joint. Correct answer is option B. That is any hurt which causes sufferer to be during the space of 15 days in severe bodily pain. This is not grievous hurt. Other hurts are grievous hurt. Question number 504. Which of the act amounts to grievous hurt? Options are option A, beating with a hockey stick, emasculation, both, none of the above. Correct answer is option B, that is emasculation. Question number 505. A causes B a superficial skin deep injury by a sword. What offense is committed? Option hurt by dangerous weapon, bleeding hurt, serious hurt. Here the correct answer is option B, that is hurt by dangerous weapon. Question number 506. Which one of the following offences cannot be summarily tried? Options are grievous hurt, theft with the value stolen properties below rupees 100, theft relating to the section 454 and 456 of IPC, offence of abatement of offences enumerated. Here the correct answer is option A, that is grievous hurt. Grievous hurt cannot be tried summarily. Question number 507. B assaults A using sharp edged weapon, resulting in an injury which is 6 meters long and half meter deep in the right forearm of A. B is liable to be charged for an offence punishable under section 323, section 324, section 325, section 326. Correct answer is section 325 IPC. Question number 508. An offence of voluntarily causing grievous hurt by dangerous weapons or means as provided under section 326 of IPC is compoundable, non-compoundable, compoundable with the permission of court, none of the above. Correct answer is option B, that is non-compoundable. Question number 509. Acid attack is an offence mentioned in section 326, section 320, section 326A, section 354. Correct answer is section 326A of IPC. Question number 510. Which of the following is an offence under IPC? Purchasing acid, throwing acid on a person with the intention of maiming or disfiguring, manufacturing acid, selling acid. Here the correct answer is option B, that is throwing acid on a person with the intention of maiming or disfiguring. Question number 511. In which case the Honorable Supreme Court has directed to pay minimum compensation of rupees 3 lakh per acid attack victim. Options are Lakshmi versus Union of India, Sanjay Mitra versus State of West Bengal, Vennagood Anuradha Samir versus Vennagood Mohandas Samir, Indra Vijay Ashok versus State of Madhya Pradesh. In question number 511, correct answer is Lakshmi versus Union of India. This is a landmark judgment. It has been asked in various examinations, so please remember this question. Question number 512. Voluntarily throwing or attempting to throw acid is an offence punishable under IPC. This we have already discussed, punishable under section 326B. Question number 513. Voluntarily causing grievous hurt to extort property or a valuable security or to constrain to do anything which is illegal or which may facilitate the commission of an offence is dealt under. Options are section 329, section 330, section 331, section 332. Correct answer is section 329 of IPC. Question number 514. A police officer tortures B in order to induce B to confess that he committed a crime. Under which section of IPC the police officer is guilty of an offence? Correct answer is section 330 of IPC. Question number 515. What punishment may be awarded for the offence voluntarily causing hurt to deter a public servant from his duty under section 332 of IPC? Imprisonment up to 3 years or fine or both, imprisonment up to 5 years or fine or both, imprisonment up to 7 years and fine or both, imprisonment up to 10 years and fine or both. Correct answer is imprisonment up to 3 years or fine or both under section 323 of IPC. Question number 516. Which one of the following sections of IPC relates to punishment for voluntarily causing hurt on provocation? Options are section 324, section 332, section 334, section 323. Correct answer is section 334. Wrongful restraint has been defined under Section 339 of IPC, Section 340 of IPC, Section 341 of IPC, Section 342 of IPC. Correct answer is Section 339 of IPC. Wrongful restraint is defined in Section 339 of IPC. Question number 518. Who voluntarily obstruct any person so as to prevent that person from proceeding in any direction in which that person has a right to proceed is wrongful confinement, wrongful restraint, force, defamation. Correct answer is wrongful restraint. Question number 519. Punishment for wrongful restraint is only simple imprisonment, only rigorous imprisonment, both A and B, none of the above. Correct answer is only simple imprisonment. Question number 520. A threatens to set a savage dog at Z if Z goes along a path which Z has a right to do. It is no offense, offense of hurt, wrongful restraint, wrongful confinement. Correct answer is wrongful restraint. N. A landlord, after repeatedly demanding and not letting the rent of his flat from the tenant H, one day locked the flat in order to not to allow H to enter it till he pays the rent to him. Which of the following offences N has committed under IPC? Wrongful confinement, criminal force, assault, wrongful restraint. Here correct answer is wrongful restraint. Question number 522. Wrongful confinement has been defined under Section 339, Section 340, Section 342, none of these. Correct answer is option B, that is Section 340 of IPC. Wrongful confinement has been defined. Question number 523. In which section of IPC the punishment for wrongful restraint has been provided? Correct answer is Section 341. In Section 341, punishment for wrongful restraint has been provided. Question number 524. Police officer arrested and detained a person in lockup despite production of a bail order from court. Police officer is liable to wrongful restraint, wrongful confinement, kidnapping, abduction. Correct answer is option B, that is wrongful confinement. Police officer will be liable for wrongful confinement. Question number 525. A causes Z to go within a walled space and locks Z in. Z thus prevented from proceeding in any direction. Which of the following crimes was committed by A? Here A has committed the wrongful confinement. If any person is confined into some walled space or walled structure and was prevented from proceeding in any direction, it will be wrongful confinement. If in any particular direction, then it will be wrongful restraint. Here the correct answer is option C, that is wrongful confinement. Question number 526. If a police officer arrested and detained a person in the lockup despite producing the bail order from the court, the police officer is guilty of, correct answer is wrongful confinement. Question number 527. A jail doctor confined a prisoner in a cell to administer anemia against his will. He is guilty of, doctor will be guilty of wrongful confinement. Question number 528. A places men with firearms at the outlets of building and tells Z that they will fire at Z if Z attempts to leave the building. Option A wrongfully restrains Z, A wrongfully obstructs Z, A wrongfully confines Z, A wrongfully orders Z. Here option C is correct. A wrongfully confines Z. It will be the wrongful confinement of Z because he cannot leave the building. That's why it is a wrongful confinement. Question number 529. A was on his journey by a car from Delhi to Agra. B met him in a way and requested for a lift up to Mathura, an intermediate town. A acceded to his request, but on reaching Mathura did not drop B there in spite of his repeated request. B was carried over to Agra against his wishes. Here A is not guilty of any offence. A is guilty of offence of abduction. A is guilty of offence of wrongful confinement. A is guilty of using criminal force. Correct answer is A is guilty of offence of wrongful confinement. Question number 530. A police officer arrested and detained a person in the lockup despite production of bail orders from the court. The police officer is guilty of, again we are discussing this question, correct answer is wrongful confinement. Question number 531. A causes Z to go within a walled space and locks Z in. A shall be guilty of, correct answer is wrongful confinement. A will be guilty of wrongful confinement. Question number 532. A police officer without warrant apprehends Z who has committed murder. Option A wrongful confinement, wrongful restraint, A and B both, no offence. Correct answer is no offence because police officer has the right to apprehend a person who has committed murder or who has committed any crime in front of him. Question number 533. A police constable compels a person to remain in police station on false case of theft and allowing him to go after receiving money from him. He is liable for forgery, cheating, extortion, wrongful confinement. Correct answer is wrongful confinement. Question number 534. In which of the following section of IPC punishment for wrongful confinement has been provided? Punishment for wrongful confinement has been provided in section 342. The act of using force by one person to another has been described in section 349, section 350, section 320, section 362, section 351. Correct answer is section A, section 349 of IPC. The act of use of force by one person to another has been described. Question number 536. Which one of the following provision of IPC relates to criminal force? Section 349, section 350, section 351, none of the above. Correct answer is option B, that is section 350. Question number 537. A intentionally pulls up a woman's wheel without her consent, intending or knowing it to be likely that he may thereby injure, frighten or annoy her. A is guilty of molestation, criminal force, assault. Correct answer is option C, that is criminal force. Question number 538. Which one of the following is not an illustration of criminal force? Option A spits over B. A removes the wheel of a lady B, causing annoyance to her. A shakes his fist at B. A pours boiling water at the bucket from which B was bathing. Correct answer is option C, that is A shakes his fist at B. This is not an illustration of criminal force. Other option, that is option A, B and D, they are the illustration of criminal force. Question number 539. A incites a dog to spring upon Z without Z. Here A has committed the offence of. Correct answer is criminal force. Question number 540. A spits over B. A would be liable for the offence of annoyance, assault, using criminal force, defamation. Correct answer is using criminal force. Question number 541. In a case, A had a dispute about possession of a land with C. C dug a well with a view to cultivate the said land, but A forcibly entered on the land and damaged well. A committed criminal trespass, mischief, criminal force, none of these. Correct answer is option B, that is mischief. Question number 542. Assault can be caused by gestures, preparations, both A and B, neither A or B. Correct answer is option C, that is both A and B. Assault can be caused by gestures as well as preparations. Question number 543. Assault cannot be caused by mere words, mere gestures, mere preparations, all of these. Correct answer is mere words. Question number 544. Which of the following is not an illustration of assault? A takes up a stick saying to B, I will beat you. A threatens B to see him later on. A medically examines a woman without her consent. A throws brickbats into the house of B. Which of the following is not an illustration of assault? Here the correct answer is option B, that is A threatens B to see him later on. All the other three options, option A, option C and option D, are the illustration of assault, but option B is not the illustration of assault. Question number 545. A shakes his fist at Z, intending or knowing it to be likely that he may thereby cause Z to believe that A is about to strike Z. A has committed use of force, use of criminal force, assault, use of force and assault both. Correct answer is option C, that is assault. Question number 546. A begins to unloose the muzzle of a ferocious dog, intending or knowing it to be likely that he may thereby cause Z to believe that he is about to cause the dog to attack Z. A has committed no offence. A has committed the offence of assault in IPC, committed the offence of attempt to commit assault, committed the offence of criminal intimidation under IPC. Here the correct answer is option B, that is committed the offence of assault under IPC. Question number 547. A person pointing a loaded gun at another person shall be deemed to be guilty of battery, assault, false imprisonment, none of these. Correct answer is option B, that is assault. Question number 548. Assault in order to outrage the modesty of a woman is punishable under section 363 IPC, section 509 IPC, section 511 IPC, section 354 IPC. Correct answer is section 354 of IPC. Assault in order to outrage the modesty of a woman is punishable. Question number 549. A demand or request for sexual favor from a woman is punishable under IPC under section 354A, section 354C, section 354B, section 354D. Correct answer is option A, that is section 354A. Question number 550. Voicerum is defined under which section of IPC? Section 354A, 354B, 354C, Section 355. Correct answer is option C, that is Section 354C.